So we'll continue with the Arbitration Act. So we are now to read out the essential ingredients of an arbitration agreement under Arbitration and Conciliation Act 1996. Arbitration agreement means an agreement referred to in Section 7, Section 2, Clause 1, Subclause B. Under Section 7, the arbitration agreement has been defined to mean an agreement by parties to submit to arbitration of certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. Subsection 2 says that an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of separate agreement. Subsection 3 specifically states that an arbitration agreement shall be in writing. Subsection 4 spells out that an arbitration agreement is in writing if it is contained in a document signed by the parties or an exchange of letters, telex, telegrams, or other means of telecommunication which provide a record of the agreement, an exchange of statement of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other. Thus, arbitration agreement stands on the same footing as any other agreement. It is binding upon the parties unless it is influenced by fraud or coercion or undue influence, etc. As per Section 7, one of the essential ingredients of an arbitration agreement is that such an agreement should be in writing. An oral arbitration agreement is not recognized as arbitration agreement according to this section. Subsection 5 states that the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference is such as to make that arbitration clause part of the contract. The implied requirement of subsection 1 is the competency of the parties to enter into contract. I will also read out contract law. So this goes hand in hand with contract law. Lack of such capacity invalidates the contract. Section 34, Clause 2, Subclause 1 makes an arbitral award liable to be set aside if a party was under some incapacity at the time of entering into the arbitration agreement. The most important element to be ascertained is the intention of the parties in having agreed to refer disputes already arisen or likely to arise in respect of a contract to arbitration. A binding contract requires consensus ad idem. Agreeing to the same thing is in the same sense by the parties. In Rickmers Verwaltung GmbH versus Indian Oil Corporation, it was held that the intention of the parties is to be gathered only from the expressions used in the correspondence and the meaning it conveys. In case it shows that there had been a meeting of minds between the parties, and they had actually reached an agreement upon all material terms, then and then alone can it be said that a binding contract was capable of being spelt out from the correspondence. If the intention of the parties to refer the dispute to arbitration can be clearly ascertained from the wording of the agreement or is otherwise clear, it is immaterial whether or not the expression arbitration or arbitrator has been used. There is no specific form in which an arbitration agreement is required to be drawn.